Hi, good afternoon, everyone. And once again, welcome you all to Logical Talk 27. Today we have with us Mr. Lawrence. Right. Thank you. So by the time everyone joins, I'm sure by now, you all know I'm going to do a customary slide. This to talk about Lawbit, what exactly we do, who we are. And one quick change you would see vis-a-vis the last slide in terms of some of the achievements, the numbers which we were sharing last last month. In fact, that have changed. Um, Lawbit is India's, we are a leading regulatory technology company providing regulatory compliance software, which allows organizations to control their regulatory risk across different entities, locations, countries globally. We have done projects in 70 plus countries. So, if, as an organization, if you are responsible for managing multiple compliances, and you have to get an assurance and a good night's sleep in terms of understanding where your regulatory risks are. Lawrbit GCMS can help you do the same. Today, there are around 550 plus entities who are taking our services and relying on our regulatory updates technology to be able to manage the regulatory risk. 300,500 plus locations and at 40 plus industries who are relying on us. Apart from the regulatory compliance software, we also offer you legal matter management solution, which is litigation, notice management software, enterprise risk management, and we offer services like regulatory compliance health checks or your managed legal operations support services, implementation advisory services, or assessment of your regulatory compliance. Today, with this, I'll just quickly now jump onto the discussions. And for everyone, today's discussion, we will try to make it as interactive as we can, because this is a very, very interesting topic. And to be really frank, when I go around, talk to different clients, this is one area where I have received the most number of queries. Not just kind of queries, but I'm saying is most number of concerns also, because there are many gray areas here. There is no right and wrong answer, and at times the things are changing so fast. You need to be on top of it all the time. How do we do that? Because there are a lot of things which are not in control. If you're, I'm saying is if companies that you're supposed to do some filings, it's in your control. But in the Contract Labor Act, there are a lot of things which are sometimes beyond your control also. So let's make it interactive. If you have any questions, queries, feel free to keep shooting them to us. I want to introduce you to our panelists, Mr. Vasant Kumar and Mr. Lawrence. Mr. Vasant Kumar unfortunately had to drop out today afternoon because there was a demise in his family. Our condolences and wishes with him. But having him here would have been very, very interesting, because this entire deck and the flow has been prepared under his guidance also. Mr. Vasant, as you could see, he was an ex Joint Labour Commissioner and CEO of Karnataka Building and Other Construction Workers Welfare Board, and he's been consulting many large organizations, corporates, to streamline their regulatory compliances with respect to labor laws, and he's done multiple webinars, workshops. But I'm sure the way he has helped us in building this work and the flow of the discussion today, we will take it from there. So that leaves the entire responsibility to run this discussion today on Lawrence. Lawrence, we look forward to hear you. Lawrence, I'm sure many of you would know him. He comes with almost 2 decades of experience of plant HR, IR, admin, and in Karnataka and Tamil Nadu, and not just this, and with his work experience has given him exposure to other state regulations and the expectations, the challenges. He is AGM of IR and compliances at Coromandel International, and he holds MSW HR from Loyola College, Chennai. And one thing before I hand over discussions to Lawrence, I want to talk about it. Lawrence brings along some very interesting insights and take about how do we need to approach compliance? Because when I specifically talk about compliance, so everything comes to our mind. How do I abide with what law says? But when I was talking to him, and Lawrence, I want to hear how you blend it with the law, and how the perspective changed. He gave me a very good example. He said, first of all, start looking at from a humanitarian ground. These are your employees who are actually contributing to your company. And I'm very, I was a connotation I was thinking about. It's actually the labor laws, the contractor employees. Sorry, they're like many of us end up treating them like a foster child. A lot of confusion in mind. Do I love them? Do I don't love them? Do I only do the compliance what law says, or do I really care for them? Now, if and the Lawrence take was somewhere in between those lines also, and then the way he then looked at the laws, it kind of made me look at a perspective very differently. And Lawrence, over to you today to take us through your experiences and your how you have dealt with this.
Yes, good afternoon, everyone. I'm really glad to connect all of you through this webinar, which has been organized by Lawrbit. I'm really thankful to Lawrbit for choosing this topic. That is the responsibility of the principal employer's liability and other things. Because these days, any either small or medium or big industries or establishment or shop, without contract labor, it is very difficult to run the industry or the shop and establishment. Everywhere we have been engaging this contract labors. So it's the essential topic. All of us may be knowing it, we are practicing it, we are complying in it. But still it is a real slight fresh up our mind, or which to fill the gap, try to understand the gray areas, or how to improve or enhance the existing contract labor management is the real topic here today. So once again, I have to be thankful to Lawrbit for choosing this topic for this webinar. I am also grateful. I am also grateful to my organization Coromandel for giving me this opportunity and allowing me to share my knowledge with all of you wherever we can enhance our knowledge. Everyone is learning, so we will learn together. So with this, I move on to the topic. So here majorly we see this legal classification, because why I am going also we have the short of time. Only 1 hour. It's not a small topic. It is a big sea in the ocean. So I would say it takes more time, but still we have a cut short it to understand the basic things and important and things. So we have a running 1 hour. So we'll run through. And I believe by going through all these things, most of your doubts or questions will be clarified. If anything, some have already raised some questions, some will be put up your questions in the chat box, which also will be clarified. So straight away we come for just basic understanding of the legal classification of principal employer versus contractor. Here we have to understand few things. The definition, definitely you'll be knowing from the labor legislations, different legislation, different acts will be giving different definitions. But we are majorly taking from the principal employer point of view and contractor point of view from the Contract Labor Management Act, because today's topic is only the relation and the responsibilities and the liabilities between the principal employer with regards to Contract Labor Management. So when we see the definition, the principal employer is a person who engages the contract labor through a contractor. So he is known as principal employer. Other word, the different act will speak about occupier, employer, whatever may be. When we speak of contract labor, it is a principal employer. And the contractor is the person who provides or supplies the employees to the industry or factory or the work location to complete a special jobs or anything. So that is he is known as a contractor. Just these are a basic understanding which we will not focus much on that. So the future slides will be focusing our requirements. Then there are some legal duties and which to be principal employer have to take certain duties by contractor. In general understanding, most of the things with regards to contract labor, the contractor is responsible. But when the contractor fails, the principal employer is liable and principal employer is accountable. So let us ensure that in the coming steps we will be explaining, let us ensure it is not only the contractor's responsibility, it is accountability lies on the principal employer in most of the legislation, most of the responsibilities and duties. So when we come to this contract labor management for legal duties, the principal employer has to ensure the main safety and health of the workman at workplace in his premise. So that is will become a major duty of the principal employer, where the contractor also partially responsible for all those things. Then apart from that, he is also purely responsible for the payment of wages to his labor, contribution of PF, ESI, then remaining welfare things also contractor is responsible. There are certain welfare comes to the principal employer. When we speak about the employment relationship to the employer, principal employer and the contractor, the principal employer owns the project or he owns the factory or the establishment or the shop, whatever, however we call it. So he is the whole responsibility and owns the project and has the vested interest in its success. Because the laborers only, they will do what the job has been allotted to them and what the work they are supposed to carry out. That is the way they will be doing. So the principal employer is the relationship becomes the major project focused, and he does not directly supervises the contract employees or contract labor. It is any contract labor, he should be supervised by his own supervisor, or we call it contractor supervisors. Please, whenever we say, please be careful, because there are certain cases where we will be engaging our own on-roll employees or supervisors or managers to supervise the contract laborers in certain these contract labor related jobs, which is legally not correct. So because tomorrow when we supervise directly the labor, then tomorrow is liable for on-roll employment, because the supervision has been done by the directly by the principal employer or the principal employer's representatives. So let us give that relationship, let contractor take care and contractor supervisor take care, and they will provide you the work required and they execute the work, whatever the principal employer allows, they will execute it. When we come to this,
Lawrence,
yeah, please.
Lawrence, you raised a very important point, and this sometimes, this is where the real challenge comes in also, because we have to draw a thin line here. Now, just want to take your thoughts here. How do you really draw a thin line? Because when the worker is coming and working in your premise, sometimes the work engagement may require him to work under the supervision of, or maybe the supervisor's responsibility, maybe with your team member. How do you really draw a thin line here?
That it is always a risk to be a principal employer, because see, we are saying what is a contract labor, wherever we can engage the contract labor, certain jobs. It is not that all core jobs are thing where we cannot engage contract labor, and which are the jobs or which are the area or what are the natures of work that we can engage the contract labor. There are two things we have to understand. We have to be very careful, because the contract labor also based on the nature of work. So nature of work where it is not a permanent in nature, because in the permanent in nature we are not supposed to engage contract labor or so-called the core job, or the call it is a manufacturing process, direct job or direct manufacturing process. So if this area, if we engage contract labor itself is a risk, then the other jobs which are not core, which are not directly involved to the manufacturing process or what may be, though where we engage a contract labor, and we are saying that there are only is a temporary job or a basic requirement or something. What is the necessary of engaging or supervising by the principal employer? So it is a risk, because when we supervise their job, on-roll or principal employer or principal employer's representative supervises the job of contract labor. It means what? You have a direct relationship with the contract laborers. When the relationship is a direct relationship, then naturally the employment goes a direct employment. Then tomorrow the contract laborers also there is a liability to look for or ask for the permanent employment. So these are the way. So let us not supervise by direct employer.
Can you explain this with one example? Maybe because you said manufacturing. So, or maybe I want to also understand from, let's say, an EPC contractor, because typically in their business, what they are offering is their core job, but the way they are I would say, I have to lay a line, electricity line from one state to another state, maybe a few hundred kilometers. I may not get employees in those locations because it's maybe a few weeks or few months of a job. Then I engage a contract laborer there. So, but it's my core job. How do I, draw a line here?
That will not become the core job because lying in the duty is not the permanent work. No, it's not a permanent in nature. They will lay until the project. It has been a project has been given to this department. They lay down this line for certain kilometers or certain things. Then the job is got over. The project is over. Then where will they engage with the permanent employment? Where will they engage? So that will not come under core job. Core job is only always comes in the manufacturing process. When there is a manufacturing process, then if you are involved in a contract labor, then that is a core job. Manufacturing process, that will work in nature. So laying cable or laying digging or lump sum work or in mining activities, certain mining activities, only the lump sum where the mining has been dumped, just we have to clear those things for a short period, or somewhere there is a dump or we have to clean certain things. Only it's a short period. After that, the work will not continue. So all these things will not come under core job.
Thank you. This is helpful.
Anyway, in my run flow thought, there are many things which will explain, which will understand the thing. Then maybe it will be at the end when we have certain things, it will be very nice. And also let the people also wait, let them pop up their questions in the chat box. Till the end, we'll have that kind of a discussion that will be more helpful. Is it okay?
Sure.
That's fine. Sure. When it comes to payment of wages, so there is a requirement to supervise the wage. See, not supervise the labor, only supervise or oversee the wage distribution by the principal employer's duty to ensure that the wages are distributed to the laborers in the particular time as per the legislation required. That is on or before 7th if the industry is below 1,000 employees, on or before 10th if the industry is above 1,000 employees. So the principal employer has to ensure. It is not that he has to pay, he has to ensure. Then we see where it becomes his liability. Then if the contractor fails to pay or make the payment in a given date and time, then the principal employer is liable and he has the full right to pay the wages to the contract laborers and deducting the bill from the contractor. And naturally, because he is liable tomorrow, because all these laborers have been worked in his premise. Naturally, so tomorrow they will claim that I have worked for the principal employer, so I should receive my wages. If the contractor doesn't pay, then it is a principal employer's responsibility. At the same time, the contractor also is responsible to make it timely payment, that is 7th or 10th. Then labor related specified by the appropriate government. Why appropriate government? Because state to state the rule can changes, but when it comes to payment of wage act, the rule remains the same, 7th or 10th. So please ensure the contractor pays the wage by 7th. If it is not paid by 7th, it naturally comes, the liability comes to the principal employer. 7th or 10th, whatever the date may be.
But Lawrence, once again, here one follow-up question here. So how long a principal employer should wait to take things in his control? Because if by
the Act says 7th. The cut-off date Act is very clearly given. 7th, the labor should be paid, receive their wages. So no how long wait or anything. Straight away 8th or 7th itself he can pay. That is the reason we ensure by 7th he submits the payment receipt or payment proof of documents to the principal employer.
Understood.
Because he has the family account, labor has its own requirement. That is the reason the date 7th has been fixed. If the contractor fails or not capable of paying that, then he is not worth to be a contractor in our industry or in our establishments. So let us not engage those kind of contractors who are non-compliant. Some of the principal employers say, I have paid the bill to the contractor, so I am not responsible for the payment of contract labor. No, please be sure, even if you pay the bill to the contractor, even the other acts also, pay your PF ESI. Once we should go to the department when the 70 inquiry comes, then we should represent ourselves, then we have paid it. Those are, so implications are there. So ensure this salary has been paid by 7th or 10th. No waiting period.
Understood. Let's Akshit move. Okay.
This is the major slide, I would say, where we all maybe us will be knowing it, but still just we go through. When we speak of the principal employer in connection with the contract labor, there are major legislations or major acts which takes this relationship between the principal employer and contract labor, and how we make this risk mitigation and best practices. Just we'll have a discussion on this. So when we understand the major acts and its responsibilities, the principally comes the Contract Labor Regulation and Abolition Act, that is 1970, which is the vital act for the contract labor management. In relation to the other major acts, that is the Factories Act. When we factories, there is a second slide. Factories Act goes to Shop and Establishment Acts. Then there is a Employees, when we, at the same time when we speak about the Contract Labor Regulation and Abolition Act, there is the Interstate Migrant Labor Act also it speaks. So they are interlinked, interconnected. Factories Act and Establishment Acts are interconnected. Then Employees Provident Fund and Miscellaneous Provision Act, Employees State Insurance Act, or the other acts like Workmen or Employee Compensation Act. Then Payment of Wage Act, Payment of Minimum Wage Act. Then there are the other acts which are related to Payment of Bonus Act, Equal Remuneration Act. Then when we speak of the other Social Security Acts, there are Maternity Benefit Acts, Payment of Gratuity Acts, Labor Welfare Fund Acts. Even sexual harassment of women at workplace is applicable to these contract laborers. National and Festival Holidays Act, all these are applicable. So there are major few acts we have brought into highlight here, and how we can make a risk mitigation has been brought here. So with this, I speak of this Contract Labor Regulation Abolition Act. What is the role of principal employer and what is the role or responsibility of contractor? When we speak of this Contract Labor Regulation, so the principal employer's duty and responsibility is to register the establishment under the legislation, under the Contract Labor CLRA Act. What is that? There are certain states speaks about 20 and above. Certain states speaks about 50 and above. It based on the state applicable rules also. If you take a Karnataka, Madhya Pradesh and all, it is a 20 and above. If a principal employer engaging as a total number, maybe with a different contractors, but the total number crosses more than 20 contract employees, then he should register under the act. That is a registration certificate. He should obtain the registration certificate. The other state, Andhra, Karnataka, then certain states speaks about 50 and above. So say a whole with the different contractors, when a principal employer engages a total of 50 and above or 20 and above, you should get a registration certificate. Then it is his responsibility also. See, please understand, as a total I said, principal employer, when it is we speak of principal employer RC, as a total 20 or 50 number. When we speak the same thing with the contractor, as a particular single contractor, if he supplies manpower to a certain industry or establishment, same number, 20 or 50 different states. Please understand, 20 is certain state, 50 is certain other states. 20 or 50 more, then he should obtain a license. Below supplying the manpower below, he doesn't require a license. But when the principal employer has a together, put together, when he engages more than 20 or 50, he should have a RC. Two different words. Principal employer is a RC, registration certificate. Contractor is a license. So that is a two different words we have to understand, different terminology. Then the principal employer also has to ensure that the contract, when he engages the contractor through particular, the contract labors through particular contractor, and if the number crosses 20 or 50 with the particular contractor, he should ensure that the contractor gets a license. If he engages the manpower without a license by the contractor or unlicensed contractor, is a major violation. So it is a principal employer is liable as a non-compliance, then it leads to major business implications. Then there is the principal employer also have to ensure certain welfare facilities. The first act, okay, the Factories Act will be coming. So in the Contract Labor Management Act, he has to ensure the welfare facilities, because we will be thinking, why I have to provide a canteen facilities to the contract labor? It is a role of contractor. No. As per that, the canteen facilities, restrooms, first aid, all comes under the liability or responsibility of the principal employer. When we see the same act, when we see the other side, the contractor, he has to obtain license, maintain registration, registers, records. What are the registers, records? There are many things. Example, attendance, that is we call it master roll, then contractor register, wage register. Because there are, see, understand, different acts will involve and comes together when we speak of registers. The fine, deduction, advance, overtime, there are different registers involved in different acts. So it is a responsibility of the contractor to maintain all the statutory registers. When we speak of Factories Act, how the liability comes for the principal employer with regards to contractor, he has to, they ensure safety and welfare of the all workmen, because every labor is working in the premise of the principal employer or the occupier or the premise. So it is the principal employer's duty and responsibility to ensure the safety, health, safety and welfare of these laborers, contract laborers. So at the same, it is not only a contract cannot be washed out his hand, it is a responsibility of the principal employer. My role is only to just to supply the manpower inside the factory, it is not it. He is also responsible, counterpart of the responsible to comply with the safety, health, welfare provisions while operates his labor in the factory limit. Then we move to the Employees Provident Fund and Miscellaneous Provision Act. There also the liability response of the principal employer is to ensure the contribution of PF, Provident Fund. And he should ensure and verify that this deduction or contribution has been made in time properly. And the other side, it is a duty of the contractor to deduct and remit. Let us see the feature slide, how we, in day-to-day activities, how we will ensure these compliances. That will be in the following slides. Similar manner, same for employee state insurance. The contractor has to deduct and remit the ESA contribution to the certain authority. And the principal employer has to ensure that he has registered, he has remitted all these things on every month on or before 15th. So it's a principal employer has to ensure, contractor has to comply. When it comes to payment of wage act, the same way, the payment of minimum wages, payment of wages to be done by the contractor, and he should maintain the registers, he should issue wage slip to his labor, everything. And the duty of the principal employer also to ensure this minimum wage is complied, and they have paid in time, and ensure that he distributes the wage slip. So please ensure time to time also inquire, ask the labor whether they receive the pay slip or not on monthly basis, whether they receive their salary on or before 7th. Everything please ensure. PF, ESI, major statutory payments if you take it is a minimum wage, payment of wage is a monthly statutory, payment of wage, then payment of remittance of PF, remittance of ESI. So apart from that, he has to maintain the registers and other things. So when I go to the other slide, I also go to, apart from this, there are certain displays also have to the principal employer as well as the contractor. Both have to display certain abstract of the acts. They have to display certain notices on the notice board. So the principal employer may provide a place for the contractor to display these notices and abstracts, or he himself should take care of the display of the abstract of all labor related acts, then related notices applicable to the different laws. So these are the responsibilities. Then this major, I also here, okay, I will be lastly I will speak about the building and other construction workers regulation of employment and the condition of service act. Before that, I will be completing this Interstate Migrant Labor Act. So it is similar to, I said, the contract labor when it is a 20 or 50, state to state differs. Interstate Migrant Labor Act, when a principal employer engages 5 or more migrant laborers. Who are migrant laborers? Employee other than the native state, who have been brought from the other state for the work in this particular state. They are migrant laborers. So as a whole, as a total, with the different contractors or same contractors, when the number crosses, the total number crosses more than 5 in a factory or establishment or a shop, this act is applicable. So principal employer must obtain a registration certificate under ISMW. Then the principal employer also have to maintain certain records with regards to migrant workers. Then he is also liable for wage, then other compliances, which when we go through that, there are many lot of compliances are there with regards to interstate migrant workmen, which many of us don't follow. Please ensure that if you are engaging interstate migrant employees, ensure all the compliances are being complied. When we come the responsibility of contractor with regards to interstate migrant labor, the contractor must obtain license when he engages 5 or more, he supplies 5 or more laborers in his particular contractor, he should have a license. Same time, he also should ensure certain welfare facilities like housing, accommodation, then medical facilities and other things, in time payment and whatever the things, because he has migrant from his own state, mother state, and he has come to the other state. So it is a responsibility of the contractor as well as the principal employer and the government role also to ensure that safety of the migrant employees. Then the contractor also maintains certain registers. He also provides journey allowance, because when these migrant employees are brought from the other state, we should pay the journey allowance, the train ticket or whatever the ticket has been occurred. We should bear the travel allowances. Then not only that, he is moving out of his mother state and coming to other state. So there is a certain allowances need to be paid. There is a movement allowance we call it. That also need to be borne by the contractor. Naturally, they will always take it from either principal employer or they manage from their own. So these allowances also have been paid to them. Same, if once the work is completed, migrant work is completed, and they have to return to their native. So again, return journey allowance also it is included. Most of us would have been experienced during COVID time, when these migrant laborers have come, they work, and during at the time of COVID, they are unable to move out or reach their own native state. then government have involved, government has given a notice to the principal employer, say that please ensure this migrant employees reaches their state in a safe manner. So we have received a notice. So this way, so we have to ensure that this migrant employees comes safely, they come, they work, and safely they return back to the native. When they work here, we have to ensure their accommodation, their support for their food and other arrangements, their medicals, and in-time payment, and other statutory related, which is applicable to other laborers.
So,
Lawrence,
yes, please. Lawrence, on the migrant labor workmen, I just want to ask you one question. Now, I am hiring some employees from my for some work. They were already residing in that city, okay, but they are from some different state. Am I now still be responsible? They were earlier working also. They are still residing in the city. Am I still responsible to pay them? As per the migrant work.
That is when this contractor first time he brought them to this state, he would have paid the journey allowances and other things. Since if you are directly bringing them from the different state, yes, these journey allowances and others are applicable. When they are already staying here, just they are only migrating from one industry to another industry by the contractor, then only we have to ensure when this contractor brought them for the first time, whether he has done all these complaints or not, we have to ensure. Am I clear?
Understood. And displacement displacement allowances also?
Also the same. When they were moving, because they were moving from their place to the other side, not only journey wise displacement, while moving the journey time, they also have to take care of their basic needs and requirements. When they move, already they have moved out and just they are staying here. If this contract is just he is removing them from there, and he has retained, he gets all the settlement clearance from the existing principal employer, then just he moves them here. That will not be applicable. But ensure first time when they move, these things have been done.
Thank you.
But once they come here, it is your responsibility to provide them accommodation, provide the medicine, provide them all the required welfare facilities, ensure that payments, statutory payments are properly made, ensure to maintain the records, everything is your thing. And you should be able to prove that these people have been just they traveled from in the state and they have come to you. That you need to prove. If tomorrow inspector comes, then if they claim that they have traveled from there, then there is a difficulties. So you should get a declaration letter or anything from the contractor stating that these people earlier brought from the different state, they have worked in this state. Now just the work has been completed by them. Actually, what the state should say, they should go back to their state, then thing. But due to certain unconditioned reasons or something, they move in the state itself to the other principal employer. But ensure, take an undertaking for these compliances.
And sorry, one last question. Now, which states minimum wages act will be applicable on this scenario? The home state or the state where they are working?
No, existing state.
Existing state.
Existing state, yes. Because I cannot provide, I have moved them, then all the people, more people from Bihar, some other state where the minimum wage is very low. Then I pull them from that state and I will be engaging them here, just I pay the minimum per day wage of 150 to 200 rupees. There are certain states still this floor wage has been not been clearly fixed. The minimum wage is very low in certain states.
Thank you. This helps.
That is the reason those state employees always migrate to the other state where the payment is higher. The wages are higher.
Yeah, understood.
I move to this Shop and Establishment Act. When the Shop and Establishment Act similar, so the contractor has to ensure that he should undergo this shop and establishment norms, rules, everything. Then he should follow the Form 3, the holiday list of the shop and or establishment. Then maintain the employment records, the registers, and other required things. At the same time, the principal employer also have to ensure that he registers himself under the legislation, that is Shop and Establishment Act, then maintains working hours, and he has to display also. He has to display on his notice board what is the working hours, what is the weekly off, what is the leave, everything he has to display. Then he has to ensure that this employment letter, the contractor issues the employment appointment letter. You would have seen these days the inspectors are giving notice to most of the principal employees of shop and establishment. Majorly they are taking that this employment letter or the appointment letter have not been issued to the off-roll people or the contract people. Because as per the shop and establishment, whoever employed, including contract people, they should get a appointment letter as per the prescribed format of the act. Then ensure the compliance of all employees, that is including contract laborers, everywhere. Ensuring the compliance of the contractor, it is accountability falls on the principal employer. Now, I will also speak about this Occupational Safety, Health and Working Condition Code 2020, which is yet to be enforced. But still, there are many things it speaks about. It is there is a good sense. There are 13 acts, different acts have been put together. That this code has been formed. Once it comes into force, it will have its own impact. There are other codes also there, but all the codes hand in hand they will be implemented. Will come into force. So certain acts, working conditions will be applicable. So when we speak of the working conditions, it is everywhere applicable. Shop, establishment, factories, everywhere it is applicable. It is also responsible to the contractor that the working conditions should be taken care. The overtime working, then holidays, weekly holidays, all these things. And also the principal employer also will take the responsibility that because overworking or overstaying of work against the act or law is not permitted. Now I come to this building and other construction workers regulation and employment of condition of service. This is only comes to where we build a new building or new construction, whether in factory or establishment, this act is applicable. And this act also speaks like interstate migrant workmen, similar manner. This act also speaks many compliances. In that, when we engage to build a new construction, we engage. So I am unable to read all your questions command now, so at the end I will be coming. So Mr. Jayant will be interacting with questions and I will be answering it. So this contractor is responsible for to assist the principal employer by providing the labor cost data. Why this labor cost? Because there is a stress. When this building and other construction workers have been employed, 1% of the cess has to be paid to the building and other construction workers cess. So there is a separate act for that. So it is his duty, he has to calculate it. Most of the time it is mentioned in the PO or work order, what is the cost involved for this construction. Then 1% will be paid. It is supposed to be paid by the contractor, but naturally by the principal employer. So always principal employer makes this payment through the contractor. Sometimes the contractor will not quote. When he quotes this his quotation, he would have left this percentage of 1% of the contribution to the labor cess. Then it is principal employer has to ensure this payment to be done. Then he has to adhere all the working conditions, then other remaining acts, the PF and other things, the insurance part, then the welfare, other things he has to also ensure. Where the welfare part, it comes to the role of principal employer because the construction is in his premise. So they are building, the employees are working in his premise. So he has to provide the required welfare facilities, including drinking water, restroom, toilet and other things. So he has to ensure as per the act applicability. Then Okay, sorry. Here the payment of cess I have spoken, then welfare facility I have spoken. The numbers when it comes to crush, the number differs because see when it is crush facilities, each act speaks of different applicability. Factories Act speaks about 30 or more women employees. Shop and Establishment Act speaks 50 or more employees. Then Building and Other Construction Act speaks about 50 and above women employees. So each act speaks of different applicability. Let us ensure, as per the state or central rule, ensure all the compliances are in place. When this liability I have spoken, wherever the act also I have been discussed already this liability part. Liability of the principal employer. So when we say obligations, so there is a wage payment. So wage payment is by the contractor. Then the welfare facilities by the contractor, where the principal employer also takes the accountability. Then PF ESA contribution, both are responsible. If the contractor fails or runs away, then it falls on the head of the principal employer. Then PF ESA contribution, maintenance of records. So contractor have to maintain, the principal employer must verify the records. So when we see here, there are certain risk mitigation also can be spoken from this slide. What is the risk mitigation is only that when we, there also next slide also is there, yeah, business, when we speak of business liabilities and other things will be coming. So when we ensure that the wage payment, the PF ESI, so ensure the PF ESI code been registered by the contractor himself, separate code by the contractor. Let us not take the liability of the principal employer, because when there are the contractor fails or he doesn't have the PF code or ESA code, then the principal employer has to pay from his code, which is there is a risk. So when you choose the vendor or select the vendor, please ensure that the vendor KYCs thoroughly go through the vendor KYCs and ensure they have a separate PF code, ESA code, then they have a current bank account, they are a compliant contractor. So this KYC is checked thoroughly. Then engage them. Have a proper agreement, systematic agreement. In the agreement, you mention everything. That is we call it 360 degree of the wage thing, where try to include whatever the applicabilities in future, gratuity or the bonus or everything, bring into the notice that in the agreement itself, and ensure that the contractor makes all the statutory payments and displays all the statutory records, abstracts, and maintains all statutory registers, and have time to time review, have time to time meeting with them, verify those records, then you may pass the bill. Yeah. So when we come business liabilities and legal implications. So when we ensure that these are complied, all the compliances are in place with regards to contract labor, our business will run without any uninterruption. So please ensure contractor, when you select the contractor, be sure we have a thorough KYC checkup, engage only the licensed contractor, have a check with them their PF code, the separate PF code, separate ESA code, whether they are complying, if, just to verify if they are engaging laborers to other locations or other factories or other establishments, and have a verification, have a reference check before engaging these contractors. Because here as a principal employer or HRs or the principal employer representative have to ensure this, because commercial department or maybe they may select a vendor, finally you should not be under trouble. So selecting of the vendor, selecting of the contractor plays a very vital role in compliance part. Then clear contract terms, that only the agreement. When we make, I think I have running a short time. When we make these agreements, thoroughly, clearly mention the agreement. What is the role of contractor? what is the role and scope of the principal employer, and what are the things need to be taken care, what are the compliances. Don't say single word, all the statutory compliance he has to maintain. No, please mention each and every act, what is the liability, what is his responsibility, what is his scope, what is the principal employer scope, everything clearly write down and make a agreement. Without agreement, please don't engage any contractor. Then registration and licensing. Ensure all the our side RC has been done, and their side all the registration have been properly done, and confirm this contract holds a valid license also, and have a follow up, a reminder chart, or possibly any tool which can remind you the expiry of their license, or remind you the shortfall payment of the statutory payments, or reminds you the gaps of the contractor. That will be more easy for us to follow and ensure that it will not disturb our business. Then wage payment, that is wage payment already have said. Then appoint any authority, because different acts says different things. Cash payment these days not permitted, the payment through bank. If there is a unavoidable reason, if the payment has been done by cash, then it should be paid in the presence of principal employer. Ensure the presence of the principal employer has been paid. Then, as per the Interstate Migrant Act, we also have to appoint a manager, interstate migrant responsible manager for their responsibility. Then, if it is Stop and Establishment Act, we have to appoint a complaints manager. So these all should be displayed on the notice board. Who is the representative of the interstate migrant employees? Who is the complaints manager of under Stop and Establishment Act? Who is all this need to be displayed, because they have to ensure their payment of wage. They have to ensure their facilities, welfare facilities. And once again, I said, please,
Lawrence,
yeah,
Lawrence, this compliance officer has to be assigned for the society, for the facility, or for the organization. Because let's say you have 20 factories, so now it should be for that location.
See, complaints manager is applicable for establishments. Shop and Establishment Act, it is applicable. So there will be a complaints manager who is equal, he has the power of the employer. Actually, the complaints manager with regards to labor law complaints. Why I didn't get your question exactly. Can you repeat again?
Yeah. So I said if I have multiple locations, okay.
Yes.
So this compliance manager has to be for the entity or for the location.
No, the complaints manager can be appointed for different locations. It's a responsibility. The name board was whose name has been displayed on the board. He is responsible. If any non-compliances have been reported, it will be reported to him. He is liable. He is responsible for the non-compliances or to ensure the compliance in particular establishments. When it comes to factory side, there is an occupier and a factory manager. So in the place of complaints manager, there will be a factory manager who has to ensure all the compliances. If it's factory, if you speak of factory, occupier and factory manager. When we speak of establishment, it is employer and the complaints manager. When we speak of contract labor, it is a responsible person or person's representative.
Understood.
Same person can remain different locations. He should hold the responsibility. Notice will be issued to him for any non-compliances.
Understood.
Am I clear? Yeah.
Yep.
So a person can be person can be, because a single person can be multiple factory as an occupier for multiple locations. No, similar manner. Yeah. There is welfare facilities. So let us, I'll run through, we'll go fast a little. The welfare facilities ensure that the canteen, restroom, drinking water, and other welfare facilities have been provided apart with the employee, or this welfare is as per the Act requirement. Then records keeping, which already we have spoken earlier. Then regular audit and review. These are the risk mitigations. Please ensure that you regularly have your audit, if possible. Once in a while, you can engage an external auditor or internal auditor or cross-location audit or functional people, function to function. You can have your audit just to find out a gap and gray areas and for the improvement. and have a weekly review, regular review to ensure that all the complaints are in place. Then the communication and the collaboration. What is communication? Is a contact, or we can say have a regular connect with the contractor, have a regular review with the contractor, and have the document verification, everything, so that keep on follow up with them to ensure the complaints are in place in time. This will be a culture. It should be a part of culture. Have a standard scheduled meeting. Every 8th, I'll meet the contractor and I'll ensure that the payment have been done. Or 7th evening, I'll ask all the contractors to come to my office. Then I ensure that the payments upon all the labors have been distributed. Then I have another meeting every 15 days or something. On or before 14th evening or 15th evening, I meet all the contractor. It is a scheduled meeting, standard scheduled meeting. Call them and ensure that this PF-ESA have been remitted and ask them to submit the document. Please be careful. There is a possibility of forging documents. I have experienced my own experience. People submitted a forging document. They will sometimes they will upload the chalanam. They will print out the chalanam copy, but they will not make the payment. Simply they will submit the copy of the chalanam, PF chalanam. Sir, I have already uploaded everything. You also will say what it has been done. Just you forget. But ensure they make the payment. How to ensure they make the payment? It is from the PF payment receipt. Sometimes that PF payment receipt also there is a possibility to forge the document. Simply from computer center they'll forge it. They'll come and submit to you. So let us cross verify it. How to cross verify? There is a TRR number. So go to Google, just type for TRR status, it will come. So the challan, the number, the TRR number, what is provided, straight away type in the Google and enter it. Automatically, any public can download that data. It is a data, is a open data. People can download where you can find whether the number of people, number of the amount, wages, then the payment of date, the receipt of bank statement should match. If it is done, yes, he has remitted the PF amount to the authority. So let us cross verify, let us doubt the contractor, nothing wrong in doubting, because there is a possibility, it is a human error that people can forge the documents. Similar manner for ESI, similar for bank statement. Bank statement when they submit, cross verify with the labor themselves. You ask them sometimes their labor bank statement, whether the amounts are matching or not. Also, time to time, discuss with the laborers as a principal employer. Please go and connect with the people, discuss with them whether they are getting the salary in time, whether they are getting PF-ESI, or the contractor is supporting them to view their PF and ESI to avail the ESI benefits, how they are supporting all these things. Please go and ensure, connect with the people, discuss with them, discuss with the labor as well as the contractor. So what is my responsibility? No, I said only supervision is not permitted. Don't do the supervision of the work. But connect with the people, it is principal employer's role, or one who represents the principal employer can connect with the people and get whether all these complaints or statutory payments are done properly. Then avoid.
Lawrence,
Yeah.
here do you also provide any kind of a training to your employees to ensure that they know what their rights are?
Yes, this is also done. Yes, I have done it where my previous planned HRs. We call it is a open call meeting, and there is a complaint development. I as a location HR go to the spot, call them, small discussion, matter of 5 to 10 minutes. Because when we see these laborers, migrant labor or the other laborers, they don't want this PF or ESA contributions. They want the amount in their pocket or in the net payment. So always people will not support to deduct the PF and equal contribution by the employer or the contractor. So I go and educate these employees what all are the benefits of PF, what all are the benefits and of ESI, what all they can think. So all this knowledge are inputted as a principal employer. I go and give them because they are working in our premises. So let them know, let them be aware of the act, let them be aware of the welfare benefits of the acts, let them be aware that the small contribution will lead to the bigger saving or bigger benefits. So when the ESA and all, when start explaining there are this many benefits or ESA benefits, the people are really happy. So they will start utilizing the benefits. Then, so they were more happy to, then they said they are all coming, sir, make a deduction. Then, how we develop this knowledge, develop this culture of bringing the complaints inside. So it's a regular duty. That's why I said connect with the people. Connecting people, not only individual connecting is a gang meeting. Here you can find most of the factories, safety department will do this gang meeting. But I have done for the labor regarding this labor social security gang meeting. Their grievance, listening to their grievance gang meeting I have conducted. So this way we can resolve their grievances. We can give them a better benefit.
Here, Laws, one more problem I have seen companies facing specifically when they have to check, whether the statutory dues have been paid for all the employees. Because you have let's say I have a contractor, he may have 1,000 people, for whom he is depositing PF. I may have engaged only 50 of them. Now he will deposit from a single challan. How do I ensure that my all 50 employees on my side have their PF have been deposited?
There are two things are verifying. One is manual verifying, another one is auto system reconciliation verifying. Both have been done through UAN number. Normally, when the vendor submits his ECR upload file, there are plenty of number will be there. For manual verifying, we can ask the contractor to highlight and provide. So that is a easy where we will be having a record. We can easily verify that is a manual. What is the amount has been mentioned in the ECR about chalana. Then we enter in our Excel file or whatever maybe and tally it whether it matches or not. Then the 1,000 employees total tally should match with the total chalana. Total chalana should match with the receipt, PF payment receipt. That way we ensuring. There are the tools which also makes this reconciliation automatically. Based it fetches from the UAN number and what's supposed to be remitted and what have been remitted. So there are tools in our system. We have a tool. There are major industries which are engaging many contract laborers, more contract laborers have these automatic tools. So based on their attendance, daily punching in and out, either biometric or different technologies, they in and out punching has been taken. From the punching, the payroll will be processed. From the payroll, the contractor also receives what he is supposed to pay the wages to his labor, what he is supposed to remit the PF to for his labor, what is supposed to remit ESA for his labor, all this ECR upload file, everything he gets a document. So he remits this. Many places we also recommend that when there are number is more, certain vendors, if the vendor agrees, he can make a separate chalanam for our own company and he can remit. That also permitted. Provided they will be making different chalanams. Each chalanam he has to pay a small chalanam paid amount there. So if he makes a separate chalanam, more is very easy for us to reconcile the document. If he refuses to make a different chalanam, if it is a bulk chalanam, we can ask the vendor to highlight and provide. And we will verify it from the UAN number or other when it comes to ESI is the ID number.
Understood. This is quite helpful.
Yes. So nowadays people are start moving to tool. There are different tools because AI has come, automation has developed, a lot of tools have start coming. So systems are more made more easy. When this only thing, we should be ready to adapt the system. We should be ready to move with the latest technologies. Which if we move, then it is more easy for us to ensure these compliances. There are certain companies, they engage separate compliance people. There are locations where the separate people, person is taking care of this contract labor and they ensure, they verify all the payments in a systematic manner and everything. when it has been verified, because see, every month the bill has been processed by the principal employer. So before to process the bill of the contractor, he can ensure all the complaints has been properly done for the previous month. Based on that, he can provide a compliance certificate. Yes, he has completed 100%. 100% yes, wage payment has been done. I have reconciliated and I have certified it. Then PF ESI, he has remitted with my data. It has been matching. It has been. Then there is a person can certify it to process their next month bill. So this is one of the checkpoint or control system which we can ensure these contractor complaints are in place every month. Only thing is that earlier some industries were doing previous month complaints this month, which already delays. Sometimes people will pay when they submit the bill for this month. The last previous month PFES remitted on 20th or something, delayed or late remittance they will submit. Still we are accepting. To avoid that one, still that is a violation. To avoid that only, now I am saying every 7th call the vendor, ask them to submit the wage pay details. Every 15th, let the vendor automatically you should come and submit his PFESA documents. So on the spot, let us verify it and certify it. So put the record in our any other system, have any either manual system or there is a tool, whatever maybe. Let us ensure that on the day of the last day, it has been ensured. If you take it as a Coromandel, we have different locations. We have all the locations. We have a system where my each location HRs, they will be entering in a shared file. When the employees, the contractor pays the pays the wages, the paid wages data has been entered in the shared file. Similar manner for PF and ESI, the data has been shared, and proof of document will also be shared, and they have a copy of the folder with them. So with that, I am ensuring I am following up regularly, and that I make sure that these complaints are in place. Similar manner, I expect all other industries, even a small industry or medium or large, to follow the similar manner. If it is a small industry, it will not take more than 10 to 15 minutes to have a thorough checkup of all payments, statutory payments, then registers. So it is very easy. Only thing that we should commit to that. We should commit to labor, because when there is a commitment, when there is a heart towards labor, we always ensure the labor gets their payment in time. We always ensure the PFESA has been remitted for the labor in a proper manner. It has been complied. So these are commitments are more important. It is not only commitment one side, there is other side. It is our business lies on this compliance. Nowadays, these compliance certificates, many business people need this compliance certificate. They expect zero compliance of industries. So let us, at least labor side or HR side, let us be ensure that there is no non-compliance with regards to employee or HR complaints, or other what I call IR complaints or labor complaints, whatever may be. So this way, let us ensure the business will not interrupted. Because if we receive any notice from labor inspector or labor department, it affects our business, it affects our image of our company, everything. So let us not give any opportunity to receive any notice from any of the labor department or the other, even factory side, the other dish or the director of factory side. Let us don't give any opportunity to receive any notice. Nowadays, it is their target also, the labor inspectors target to visit the industries, visit the establishment and check all these things thoroughly, because it is their, become their target. So please, you may be aware here, those who are attending would have received or would have met many inspectors in your location, in your factory, in your establishment. Some would have received even notices, some would have managed not to receive notices, some would have perfectly complied and would have proved that you have perfectly complied. So all this way, let us ensure the compliances are in place. Coming days, there are all the industries are, our government is focusing majorly on compliances. Labor themselves are well aware of the compliances. They themselves are ready to go and give a complaint to the labor department. My wage is not paid properly. I am not getting the minimum wage properly. I am not getting these welfare facilities properly. My welfare facilities are not in a good condition. My working condition is not okay. So labor themselves are, because everywhere we are supposed to display the inspector name, inspector contact details, or labor commissioner or enforcement officers contact details. So the employee themselves are going and making this compliance. So let us not give that opportunity. That is the reason I said connect to people. Go and speak with them regularly, receive their grievances. By receiving their grievances, we will understand what are the compliances, what are the non-compliances. If we find any gap or any gray area, please fulfill it. Ensure we are zero non-compliance company or 100% compliance company. My CHR also often says 99.999% of compliance is equal to zero non-compliances. So 100 only makes 100% compliances. So let us not say only a small complaints has been, I have failed to do only small complaints. Just only one day has been delayed. My labor payment has been delayed only one day. My PF ESA has been delayed only one day due to website problem. No, it is still is a non-compliance. A employer or contractor or principal employer will receive a notice. And other once more practical experience, I also want to say that when we verify this PF, please also ensure that your contractor gets the PF code in your own state. We engage a contractor vendor from different state. They will be having their own PF account in the different state. They will remit the PF contribution. Though it is a nationalized act, they remit their PF in their particular state. Tomorrow, if they fail to remit or if there is any non-compliance, if notice is sent to the contractor, and if the contractor, okay, there are different checkpoints their PF office is having, they will block their current bank account. Still, if they are not bothered, or if they are not attending the inquiry or any 70 inquiry, whatever inquiry, the contractor, the next notice comes to the principal employer. Principal employer have to go and attend the inquiry meeting in that particular state. Please ensure. If a vendor is engaged in south of Tamil Nadu, Kanyakumari, and that contract is having or remitting or contributing his PF amount contribution in Indore PF regional office. Tomorrow, if there is any non-compliance or the contractor fails to remit there, any inquiry falls. If the contractor doesn't attend the inquiry, the Indore PF regional office will send the notice to the principal employer who is in Kanyakumari South. And the principal employer who sits at Kanyakumari has to go to Indore to attend the inquiry. So these are the difficulties are there. Please be careful when you choose or when these PF codes are generated. Okay, still the PF is there. When the non-compliance comes, we ensure you have to attend the inquiry at the regional office where he has the account. Okay, here there are real-time scenario. If you can just go through it, there are some scenario one, background and facts. The contract had a valid CLRA license, but had not registered.
So Lawrence, let me just do a quick poll, because I want to, I don't want you to rush very fast, because this is important. These are, some real scenarios. I want to quickly ask everyone, if you are okay to extend for next by 10 more minutes, please just raise a thumbs up. Great. Thank you so much. So, yeah, Lawrence.
Yeah, happy to show that.
Yes. Let's not rush, because these are important.
Fine. So I'm happy, because I also definitely the beginning I said is a vast subject. It is 1 hour or 1 day is not enough to understand the full impact and everything. But still, based on this, when we put up everything in the practical scenario, we will develop, we will understand, we will comply to it. So when we take this real time scenario, there is a background fact has been given here. The contractor had valid CLRA license, but they have not registered the workers under ESA or PF. So this, I think, is it each scenario, each box is one scenario, Jayant?
Sorry?
Okay, then this scenario we can understand. Okay, when this scenario comes registered, when this vendor has registered CLRA, but it is not registered under PF ESI, directly his labor's PF ESI will be liable, or we should remit from the principal employer's PF number or ESI number. So please understand this one. Anything you let me know. Then wage were frequently delayed and no salary slip were issued is a non-compliance. Please ensure there are certain wage payment, when it regards wage payment, even it has a penalty of imprisonment too. So ensure if the vendor is frequently delaying any non-compliance, whether wage or PFDSI, better I would suggest terminate the vendor, terminate the contractor, or blacklist the contractor. Have only the compliant contractor with you, which will smoothen your business. Otherwise, your business always will be interrupted and you will face a difficulties. Then other scenario, there are two female contract workmen faced inappropriate behavior by the line supervisor employed by the contractor. The company's past internal committee refused to entertain the complaint, sitting they were not on company road. Is it okay? It is accepted? No. I said in the earlier itself, this sexual harassment of women at workplace is applicable to even contract workmen. So your internal complaints committee also ensures the safety and security of your women worker, of the contract women worker. So if the internal complaints committee refuse to receive the complaint, naturally the complaints goes the next authority. Then it troubles the industry. So it is the principal employer duty to ensure the safety of the women at the workplace, because the act is covered for them also.
I just want to add one small thing here for benefit of everyone. See, if you had attended our previous webinar on the wages, code on wages, there also I spoke about, in India there are multiple acts which are defining different scenario. Like here example, when you're talking about labor employees, as we have a CLRA, we have Factories Act, we have ESIC, EPF, minimum wages, gratuity, POSH. Every act is dealing with employees. These are labor acts, right? But every regulator defines certain words differently. Now, sometimes the challenge for what happens with us, we are reading it from the lens of let's say CLRA is a contract labor. I'm reading it from the lens of CLRA, but the scenario may fall under POSH. Now I have to understand the definition of employee in CLRA and in POSH also, because when the problem, when in this, when the litigation or the notice will come to you, it will refer the definition of a different act. So please be mindful of them. And these are very, very critical and sometimes confusing also. But yes, that's a reality. So you have to be very, very mindful about reading these definitions. And somewhere, if you are a GCMS user, if you are a software user, you would know there is a definition tab, and you can go and compare definitions across multiple acts at a single place. Use that. This will be very, very helpful, very handy to you in understanding these kind of scenarios. And these are always forced, it's not intentional mistakes at most of the time. These are, something which you overlooked because you may refer a definition of an employee in one act, but not in the other act.
Sorry, yes, we have the answer when all this course comes. So because they are trying to put together all these definitions, everything. As of now, as you rightly said, each act speaks of same word but a different meaning when it is a definition. So we should take with the relevant to the particular act. The wage, when it speaks of wage, PF Act speaks different, Payment of Wage Act speaks different, Minimum Wage Act speaks different, Equal Remuneration Act speaks different. So that we have to understand. When we speak of the definition of workman or employee, each act, ID Act speaks a different meaning, Factories Act speaks a different meaning. So let us understand with the scenario and we have to apply to the requirement based on those particular acts. That is right, please. That only we have to understand. Whenever we quote the act, we should take a particular scenario and relate it to the act. Then we should take a definition from the act. Then we should see the case study. I believe I am clear.
Yes.
Okay, there is a during routine inspection. A labor enforcement officer found that no safety induction or PPE was provided to the workers or the contract workers. Yes, again, it is a violation of the principal employer, because we in the beginning we saw the principal employer has to ensure the safety, health of the workman who are employed in his premise, whether he is on road or off road or contract, whatever may be. So he cannot say no, he is a contract labor, he is under the supervision or under the role of a different contractor. He has to ensure the safety, whatever may be. He has to ensure, but if any person is found unsafe, if any person is found unsafe condition working, any person meets with an accident, naturally the concern lies on the head of the principal employer. So please ensure it is a role of the principal employer. You may force the contractor to provide the PPE, personal protective equipment, but still you have to ensure if any person is found or met with an injury or anything, it is liable on principal employer. A contractor forklift operator suffered any eye injury due to chemical exposure inside the raw material warehouse. Still, it is a safety. So, it comes under all the safety related thing. So, it is a liability of the principal employer. The principal cannot escape simply. No, it is a contract labor. It is responsible to the contractor to take care of the labor. No, it is we are liable. So, that is the reason. Ensure you principal have to ensure. Otherwise, we are liable. Notice will be straight away. It will be issued to principal employer. Any accident takes place for the contract labor in the premise of the factory or establishment, notice will be issued to the principal employer, not the contractor. Please be very clear. Any accident takes place in the premise to the contract labor, the notice comes to the principal employer or occupier or employer, not to the contractor. Please ensure. So ensure all these scenarios are responsible for the contract for the principal employer. There is a legal analysis, another one more. That only whatever we spoke, the below there is the thing CLRA what it speaks about the section and everything. It has been given the clarity, so we can understand it for the thing. There is another scenario number 2. Background or facts. Workers were hired on site with no formal employment contract or displacement allowance or journey fare. This is one scenario. So here who has to take the responsibility? Naturally, if the contractor is not done, the appointment order is not given by the contractor, or the displacement allowance or journey allowance is not done, then it lies on the principal employer. So before hiring any labor to the site, ensure he gives an employment contract letter. He ensures that he has brought them with proper journey fare. Then he has paid the displacement allowances. Please ensure. The contractor did not maintain any ISMW registration, nor did it register the workman under BOCW or pay the required cess. Naturally, it is a liability of the principal employer. Nowhere we can escape. It is not my labor. It is not my employee. So we cannot escape in any of the situation. Principal employer is liable to maintain all the registers records if contractor fails. Principal employer is liable if the cess is not paid. So when the contractor doesn't pay the cess, then imagine the project cost will be a bigger cost with the principal employer. The whole project cost, 1% of the allowance will be, will receive notice to be remitted or paid. So ensure the cess, everything has been properly paid. No record of PF ESI enrolled were available. In that situation, let us not engage the contractor. Ensure a 7A inquiry. 70 PF 7A inquiries always will ask for the record. They have the right to ask the 10 years record. So ensure all the records are properly maintained. So whenever the inspector inquires, the contractor should provide. If contractor fails, it's the response of the principal employer. with a penalty and damage, it will be liable on principal employer. Two workers were severely injured while handling reinforcement bars. They were neither covered under ESI nor compensated promptly. So, in this case, we also clearly said, please ensure ESI, without ESI registration, not enter even to the gate, I would say. Many people will say, sir, he has come for an interview or the selection process. Still, the laborer has come for a selection process in the premise of the principal employer. While coming the selection process, he has crossed the security gate. When he was moving just a little for 10 meters, he found there is a speed brake. The laborer was not aware because he is not yet deployed in the site. Just he has come for a selection process. He fell on the floor by a hit of any stone or speed brake, whatever may be, some major injury, or even he has passed away, whatever may be. It is liable because any injury has taken place in the premise of the factory or establishment, so we are liable. So please ensure any labor who comes, ensure he comes with the registration of ESI or covers under Workmen Compensation Act or Employee Compensation Act. There are scenario cases where straight away where there is a ESI applicability and the labor wage is less than 21,000 and the contractor brings the Workmen Compensation Insurance, named or unnamed. Still, if some injury takes place, that will become invalid. So please ensure the Workmen Compensation Insurance is valid where there is a ESI exemption or the labor wage is more than 21,000. If it is both are not there, please ensure the ESI has been covered. On NGO flagged the matter to the labor commissioners, triggering on a site inspection. Yes, so anything, if anybody gives a why the labor NGO, even the labor themselves will be a complaint or commission or they give input, the labor commissioner or the inspector will inspect the industry or factory or establishment or shop, and necessary action will be initiated, which will disturb the business, which will spoil the image of the organization and all these things. So please don't give any opportunity to non-compliances. With this, I also would like to close it. There are some case laws, which case laws need to be, each laws need to be understood and read in a proper manner. So just you can highlight it and you can go through those case laws in your, when you have a time, or in another session when we can go in a deeper manner, all these things. With this, just I want to close it. Now it is I hand over the platform to you. So any questions, answers, if I am left over, if I am not explained your doubts, if I am not explained your requirement, you may raise here.
No, in fact, Lawrence, I should have named it as a master class in contract labor. This is very, very informative session, and the way you covered it, it was really great. And you rightly said, this topic possibly does not need an hour; it needs a day, or maybe more than a day to have a discussion. I think we will have a lot of questions. It's not that I do have questions, but I'm also looking, mindful of the time. It's already 5:30. We have 30 minutes. We've already crossed. But I just want to end the discussion with one small thought from my side, and this is basis my experience. See, specifically when I've interacted with organizations, I have realized, one common thing comes across, and there are a couple of laws where you talk about BOCW or, Interstate Migrant Act. The cost of non-compliance is higher than the cost of compliance. This is a common thing which come across from people, that why do I need to do this compliance when the cost of non-compliance is lesser than. But as you have seen certain cases, you're seeing certain case laws also, and also the change scenarios. Sometimes something is not important today, but as Lawrence and I were discussing about it, while we were preparing for interstate migrant, most of the people say it's not important, but certainly there are political compulsion. The political change is also happening and there are inspectors going around doing inspections, doing checks, asking for data related to interstate migrant. Now, this has certainly changed things, equations. Good, bad, ugly, it's okay, but you are under scrutiny. If you're on the wrong side of law, you know what can potentially happen. BOCW. I've had a scenario wherein the chairman of a very large company was summoned because of a non-compliance during the inspection in BOCW. Can it happen? Normally you would not heard, but he was summoned, and you tried managing it through their lawyer, through the representation. No, it didn't have work out. Ultimately, the chairman had to be present. Imagine, very large listed organization, multinational. The chairman was summoned. Sometimes go for
a
a
small
small
here also. Just I want to break small break, because see, there are certain state earlier BOCW can be registered by power of attorney or any representative by the employer. But now, even if you take Tamil Nadu and all, they are refusing. They are refusing to register BOCW with any representative or power of attorney. They want the owner themselves, whose name is in the list of directors, because of certain case studies and case laws, some scenario. Straight away they want to register it only on owners. Without owner, they will not register BOCW, because direct implication, that much implications are there. Yeah, please,
yeah. Right. So, so in this, suddenly change scenarios, it can have a very, very higher implication. The some small license can be cancelled. It can have a very large impact. So it is important, to look at, as Lawrence rightly said, 99.99% compliant is not compliant. In this scenario, you have to be 100% compliant. I think let's start looking at it. And somebody had mentioned a point here. Do I really need a labor, contract labor, when all the obligation is on me as a principal employer? If you have to run a large business, if you have to run constantly evolving, changing scenarios, you would require a contract labor in all the scenarios, whether it's a factory, whether it is your IT setup, your EPC business. Every business require a contract labor today. You can't have you can't build those non-correct activities in your business. You will need them, but is that how much you are aware, so that you're avoiding any scenarios where they could have a potential risk. With this, I think we would conclude. I know there are a lot of questions, and I want to also thank everyone who were being very interacting on the chat session. Jiva, I don't know if you are there. I specifically want to thank you. I saw you addressing a lot of queries on the chat, and this was I would say was one of the most interactive sessions, specifically when I was looking at the chat. And again, many questions are still there. I would say we will maybe possibly come back and have a follow-up session. And you and Lawrence, we would possibly look at something, at this follow-up, maybe last slide, case laws, because these are very, very important ones, and they give you a very practical scenarios also. Thank you, everyone, and look forward to you in the next session. Thank you, and thank you so much, Lawrence, once again. It was very, very interactive and very, very informative session.
Thanks, Lord. Thank you. Only thing, everybody's not getting an opportunity to interact, because very interesting session it is. When we interact and ask question and answer and given only little bit, that only till the time is not enough. It needs a day and face-to-face or a more interactive question answer, where we can clarify all our doubts and other things. But finally, I end with, please ensure 100% friends. Again, I repeat, 100%, where we can, our owners can sleep peacefully.
Yes. Thank you so much.
Thanks,
once again. Thank you, everyone.
Thank you.
Have a very, very good day.